Welcome to On the Beat, everyone. I'm Troy Thompson. Joining me in the studio today is Sarah Cline Stevens, attorney at law. And today, it's the age-old question, when is it too late to do anything about estate planning? Welcome to the show, my friend.
Thank you for having me.
Okay. I was talking to you off camera and I'm having some checkups and some light procedures done, and I've been interviewing you now for several months, and I've been thinking about, I don't have a will, I don't have any direction of estate planning. When is too late too late? And is it ever too late?
Well, you know, I hear that question all the time, you know, or I hear it's never too late to do estate planning, and that's not actually true. It can be too late, and especially if something happens and a person becomes unable to really articulate what they own or who their loved ones are, how they want it to pass, they might have, you know, kind of missed the boat on that. So, and what makes a person competent or capable of doing estate planning is a really difficult thing to articulate. And society's starting to realize that. Banks and financial institutions are becoming more and more hesitant to honor powers of attorney because they're not sure, you know, was that principal actually capable of understanding what she was signing? And so it's becoming more and more of a problem.
So you're saying to do it sooner rather than later. And what constitutes too late? Because it was interesting what you said about the banks not honouring sometimes.
That's right. So it's definitely going to be too late when a person is unable to state who their family or loved ones are. If they're unable to articulate what they own and how they want that property to pass, or they're unable to understand the type of document that gives them the ability to designate someone to help them, like if they don't understand what a power of attorney is and they can't articulate that to the person who's in front of them, then that's too late.
Can you articulate that for our audience at home? What is a power of attorney?
Sure. So a power of attorney is a legal document that allows you to designate someone that you love and that you trust to make decisions on your behalf. I call them like personal business decisions, like dealing with the IRS or your taxes or your banks or your banking institutions and accounts that you might have. A power of attorney is going to authorize somebody to act on your behalf for that.
Someone wrote in saying, so what happens if it's too late, question mark, say my mum has Alzheimer's and doesn't remember me anymore?
The reality is her time to execute estate planning documents, it just may have passed. Not always is an Alzheimer's or dementia diagnosis like the kiss of death for capacity. That's not always the case. A person may still be able to understand those things even if they've gotten a diagnosis. But as that disease progresses, sometimes it does affect their ability to be able to articulate those important things and to be able to seek out the help that they need independently and make those types of decisions.
Okay.
So if it's gotten to the point where, you know, your mom's unable to recall your name and she doesn't recognize you when you come in, certainly I would not be executing a power of attorney for her.
Okay, because it could be overturned, is that what you're saying?
Well, absolutely, it would be challenged for being valid. Did she know what she was signing? Did she know who her other options were?
And that's, of course, if there are complications within the wills and things like that when our loved ones pass on, right?
That's right. Or somebody might have taken her to get a power of attorney that didn't need to be her power of attorney.
I didn't think of that.
And maybe they're using it for not appropriate purposes. Like we're going to talk about later on, you know, vulnerable persons. Powers of attorney are one of the most often used tools to unduly influence somebody.
We've talked previously about conservatorships. Okay, so what if a person is under a conservatorship? Can they still execute an estate plan?
Yeah. That's a complicated maybe. The Mississippi Supreme Court has ruled that just because someone is under a conservatorship doesn't mean they're not necessarily capable of doing a last will and testament.
You give us such great information. Everyone at home, if you want to find out more about Sarah Cline Stevens, of course, attorney at law, give her a call. There's all the information up on the screen. You know she will take care of you. Thank you so much.
Thank you.
Back after this short break.